On a recent episode of Glenn Beck's podcast, he stated that the prosecution of Barack Obama is never going to happen.
She says that he should be indicted and prosecuted. Not going to happen. Just not going to happen.
He and some other political commentators believe that because of the Supreme Court's decision on presidential immunity, that it's not possible to prosecute a former president. But if you look closely at the actual language of the decision, it's quite clear that they weren't giving a blanket immunity for presidents. So I want to examine that here today. You know, in the annals of American political history, I don't think there's a single scandal to rival this insidious Russia collusion hoax perpetrated against President Donald Trump during his 2016 campaign and early presidency. This wasn't merely a misguided investigation, but a deliberate deep state orchestrated effort to undermine a duly elected president and subvert the will of the American people. These revelations, declassified by Director of National Intelligence Tulsi Gabbard, have laid bare the shocking truth. Former President Barack Obama was at the center of this conspiracy, directing efforts to manufacture intelligence that falsely accused Trump of colluding with Russia to steal the election. Think about that for just a moment. Here we have official documents showing Obama administration officials like CIA Director John Brennan and FBI Director James Comey fabricating narratives about Russian interference, all at the behest of a sitting president to destroy his successor and thwart the will of the people. How is that anywhere in the realm of presidential duties? Of course, we conservatives knew this was the case the whole time, but the left laughed at us and mocked it as another conspiracy theory. Well, who's laughing now? You know, as conservatives, we champion the rule of law, limited government, and accountability for those who wield power. So this exposure of Obama's role really demands swift action, a thorough investigation followed by charging and prosecution for crimes that really strike at the heart of our republic. So let's look at the Supreme Court's landmark 2024 decision in Trump versus the United States, which granted presidents immunity for certain official acts, but explicitly rejected blanket protection. This ruling isn't a deterrent for prosecuting Obama, but a clear path forward, as his orchestration of the hoax, potentially rising to the level of seditious conspiracy or even treason, falls squarely outside the realm of legitimate presidential duties. Now, I want to explore the hoax's origins here, Obama's central involvement, the Supreme Court's framework on immunity, and why prosecution is not only possible, but imperative for Obama and his conspirators, including Hillary Clinton, James Clapper, James Comey, and John Brennan. The Russia collusion hoax began as a desperate ploy by the Obama administration and Clinton campaign to deflect from Hillary's electoral failures and delegitimize Trump's victory. Funded by Clinton's campaign, the infamous Steele dossier, riddled with unverified Russian disinformation, was funneled through Fusion GPS to the FBI, sparking the Crossfire Hurricane investigation. Declassified documents now reveal that Obama was briefed on these efforts as early as July 2016, with Brennan warning him of Clinton's plan to tie Trump to Russia as a means of distracting the public from her use of a private email server. Far from distancing himself, Obama allegedly greenlit surveillance on Trump's associates, including illegal FISA warrants based on the dossier's fabrications. This wasn't intelligence gathering. It was a partisan witch hunt designed to cripple a political rival. As President Trump himself stated, accusing Obama of treason, this conspiracy manufactured evidence to undermine the 2016 election and sow chaos in our democracy. So if proven, Obama's actions could constitute seditious conspiracy under 18 U.S.C. 2384, which criminalizes plots to oppose by force the authority of the U.S. government or prevent, hinder, or delay the execution of any law. Fabricating a national security crisis to interfere with a presidential transition fits this bill, as does potential treason under Article 3, Section 3 of the Constitution, if it involved giving aid and comfort to enemies by leveraging foreign disinformation against a domestic political foe. This isn't hyperbole, but it's really a grave betrayal. Obama, sworn to preserve, protect, and defend the Constitution, instead weaponized the executive branch against it. Tulsi Gabbard's report underscores this, labeling it as a treasonous conspiracy involving Obama and his inner circle. Now, some Republican senators have already called for a special counsel to investigate, emphasizing that declassified materials incriminate Obama in directing this plot. So let's look at the Supreme Court's decision in Trump versus the United States to see what, if anything, can be done here. Chief Justice John Roberts' majority opinion clarifies that presidential immunity is not absolute but tailored to protect the office's functions. The court held, and I quote here, under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. And he is entitled to at least presumptive immunity from prosecution for all his official acts, end quote there. However, this protection is limited because they go on to say, as for a president's unofficial acts, there is no immunity. See, the opinion emphasizes that the president enjoys no immunity for his unofficial acts, and not everything the president does is official. This distinction is crucial, as orchestrating a hoax to subvert an election opponent is manifestly beyond his authority and cannot be shoehorned into core duties like foreign affairs or law enforcement. The court further supports prosecution by noting the parties before us do not dispute that a former president can be subject to criminal prosecution for unofficial acts committed while in office. In dividing official from unofficial conduct, courts may not inquire into the president's motives, but must assess if the act falls within the outer perimeter of official responsibilities. Obama's alleged direction of fabricated intelligence against Trump, done to aid a political ally like Hillary Clinton, bears absolutely no relation to constitutional duties. It's a private, partisan scheme akin to the example cited by Justice Barrett in her concurrence, where she says the president has no authority over state legislators or their leadership, so it's hard to see how prosecuting him for crimes committed when dealing with the Arizona House Speaker would unconstitutionally intrude on executive power. Similarly, Justice Sotomayor's dissent, while critical, acknowledges the majority's view that the president is subject to prosecution in his unofficial capacity, reinforcing that unofficial crimes like seditious conspiracy remain fair game. This framework demolishes any immunity claim for Obama. Treason or seditious conspiracy is not a presidential duty, it's antithetical to it. As Hamilton wrote in Federalist number 69, cited in the decision, former presidents are liable to prosecution and punishment in the ordinary course of law. The Constitution's impeachment clause, referenced by the court, contemplates some form of criminal liability for former presidents, including for acts like bribery that implicate official conduct, but unofficial abuses like Obama's hoax receive no such shield. Even presumptive immunity for non-core acts can be rebutted if prosecution poses no dangers of intrusion on the authority and functions of the executive branch. Prosecuting a former president for conspiring to undermine democracy enhances rather than intrudes on executive integrity. So by this logic, Obama's co-conspirators, none of whom enjoy presidential immunity, must also face justice. Hillary Clinton, whose campaign bankrolled the dossier, should be charged with conspiracy as well to defraud the United States. James Clapper, the former director of national intelligence who lied to Congress about surveillance, and John Brennan, who briefed Obama on the plot, both fit as key enablers. James Comey, who signed off on flawed FISA applications, and others in the FBI cabal represent the deep state's rot. As Tulsi Gabbard's report details, these individuals manufactured intelligence under Obama's watch, forming a seditious network. So we definitely need a special counsel here, one untainted by Biden-era holdovers, to probe all of these ties. It's really the only way to restore faith in our institutions. And I firmly believe the Supreme Court's immunity ruling actually paves the way for prosecution by limiting protection to official acts, excluding treacherous schemes like Obama's here. So we conservatives have to push for investigations that expose the full truth, charge everyone responsible, and ensure such abuses never happen again. Letting Obama and his allies escape justice would mock the rule of law and embolden future tyrants. If we truly want to drain the swamp, this is the way to do it. Start at the very top.
The real beef.